Hey guys, good afternoon. Hello, hello. Hold on here. Hello, hello. Come on. There we go. Hello, everybody. Hope you guys are all doing well. Welcome to Tuesday afternoon. And yes, we are going over Nick's response to the Frank's motion to suppress. I know Nick's saying like it's not what it is, but it is what it is. So, welcome everybody. My name is Sean Martin, also known as Potentially Criminal. I am an attorney in the Cleveland, Ohio area. Do a lot of criminal defense stuff, obviously, with the name criminal. So, that's what we're doing here. That's what we're doing. And yeah, so if you guys are not familiar with this situation, Nick Rekieta, obviously, of Rekieta Law here on YouTube, which is apparently not a law channel, but it is a law channel, kind of. And actually, hold on, I have to close the door. So, we're going to use the sword. That. German longswords have multiple uses. Anyway, he is the proprietor of Rekieta Law here on YouTube, a not law channel anymore, apparently. Anyway, Nick was raided in May on a search warrant based on allegations that there was cocaine in this house. This all stemmed from basically him being involved in some weird kind of swinger stuff. And from there, everything kind of fell apart. And the two couple swinging turned into a threesome, kind of how it normally goes. And eventually, Nick ended up getting ringed by the police. They found 26 grams of cocaine in his house. He was also charged with having firearms while in the possession of drugs, which is a violation of Minnesota law and also a violation of federal law under 18 U.S.C. 922G. Now, once again, you can argue whether or not that's valid or constitutional, but right now the law is what it is. And then he was also charged with child endangering because children were in the home where 26 grams of cocaine were hanging out. Now, there were multiple things that happened. Nick's kids were removed from the house. And, you know, there were all kinds of stuff going on with that. We've already covered all that. That's all actually been resolved. And like I said, that didn't turn out on the timeline I thought it would. But as of right now, Nick and his family are in some sort of protective supervision mode where Children's Services is observing and monitoring the situation. And at some point, they will terminate that. But for right now, it appears the children are home. So as I said before, my hat's off to Nick on that. In the meantime, he has been charged with felony possession of cocaine. Under Minnesota law, he faces up to 25 years in prison. Now, do I really think that's going to happen? No, that's going to happen. With the firearms, it is up to a year, up to 364 days in jail as a misdemeanor. The child endangering is another misdemeanor as well. So what do we think? You know, I've said it before, and we'll cut to the chase, as I've said it previously. Jail is not the likely outcome here. In fact, I actually bet somebody like 20 pounds, so like $25. He is not going to go to jail. Absent other circumstances, but just as a normal issue of this, he is not going to go to jail out of this. So let's get to the chase. You wonder if I'm wearing a belt and suspenders. That'd be a hell of a belt. No, suspenders are doing God's work today. Looking spiffy today. Yeah, well, I came straight from court. I didn't have a chance to. I mean, I got home 5:15. So, and I will apologize, guys. I know the thumbnail kind of sucked, but that's the best I can do in a court, like in the parking lot in front of a courthouse. Well, I didn't in the parking lot. I was on one of the parallel parking spaces, a parking space in front of a courthouse on a street, working with Canva on my phone. That's the best I could do. So it's not as good as I normally make things. It's not the same fonts and all that. I apologize in advance. That's the best I could do on the road with the away game stuff. How much is TYT paying me? Wouldn't you like to know? Wouldn't you like to know? That's between me and Anna. And Lois said, am I ignoring us? Nope. Just get through the basic spiel. So anyways, getting back to the case, Nick is challenging the search warrant, and he's challenging the search of his home. He filed through his attorney, what's called a Frank's motion under Franks v. Delaware. And he's challenging the veracity of the affidavit itself. So the affidavit that was used to apply for the search warrant. He's basically saying that the cops lied. And he's saying that in addition to that, their lies were material, or if they weren't lies, they were so reckless that they should have realized there was something wrong with the information they were relying upon. Now, they had a brief hearing about this, their omnibus hearing. The state wanted time to respond, which I think, that's only fair. You file a motion, everybody gets to respond. The state responded, and they responded very succinctly. And I think they, once again, the state did a good job of articulating their things. Unlike Nick and his attorney the first time through, it was a disjointed, slapdashed, kind of hot garbage. It was. Let's be real. That's what it was. It was hot garbage. And let me see here. Where is? Oh, and damn it! I just clicked out of the thing I wanted. Hold on, chat. I got to go back and look for this real quick. Oh, where did it go? Where did it go? Oh, come on. Don't tell me I lost it. Don't tell me I lost it. Oh, crap. We're going to have to look for it in a minute. Anyways, this was... Oh, hold on. I lost my train of thought today. Why do I look like Gumby? Because it's the shirt I wore today. Now, let's get to the motion. Let's get to the motion that he did file, because I do think it's important to start looking. Yeah, it's in history, but I can't find it. It's not showing up right away. So if you guys know what I'm talking about, it's by Third World Aristocrat. It's the Rekieta Law versus Rekieta Law thing. That's what I was looking for, because I think it is very good at what it does. Actually, hold on. I think Alyssa's got it in here. No, I don't think she has it here. Crap, I can't find it. Oh, if any of you guys have it on Discord, send it to me. So here we go. Wait, hold on. What did I proofread my intro? Oh, Nick. Okay, yeah, I messed up my intro. Somebody's trying to help me. All right, so let's get to the motion. Eternal Boomer. Bow ties. I don't do well in bow ties. Bow ties don't work on fat guys, because there's all this real estate. You can't do a bow tie. You got to get skinny again if you want to do a bow tie. So James says, frankly, I'm leaning towards Rekieta. We'll get to that, and we'll say why I don't think that's the case. But you're allowed to think that. That's how this goes here. No, I did not dress up for Anna, guys. So here we go. The motion was filed. Now, I know people were like, oh my God, nothing had happened. Well, just like the issue with Kayla's bond, it took a couple of days. So it was worth waiting to make sure nothing had happened. And this popped up on Monday. And that's because it got filed pretty late, 8 o'clock at night. Now, I will say, just looking at this thing as a whole, it's nice, it's orderly, it's justified. You've got headings. It looks good. You've got headings, you've got block quotations, which is how you do it if you're trying to quote a lot of things at once. We've got like italicized citations. That's the way I prefer to see it. You've got, subheadings here. You've got, and we've got, look, here's what we're talking about. Not just making weird accusations, but saying, listen, Helen, listen, honey, here's what we're doing. Listen, Linda. This is stuff where when you look at it, why is this important? Because this shows this is serious work. Okay? And we're going to get through all this. I just want you guys to see, this looks good. Like, I'm like, holy cow, I actually like this. This is like, I'm not trying to be a smart ass, but 10 out of 10 on style alone. Because when you see something that's properly formatted, you're thinking, okay, these people are with it. They're with their shit. That's a very critical thing. You have to. Because it's professionalism. I mean, this almost looks like it's written by an entirely different person, which is kind of sus to me, because it's an entirely different, and even the grammar in this is a little different vocabulary, but just the formatting and style. And we all have our stuff. And here's the thing: if you guys don't write for a living, and attorneys, we don't like write like like a guy writing a book. Okay, people who write books, but we do have writing styles. And for example, when I worked in a prosecutor's office, when we would file motions, the judge could tell whether it was me or as one of the other assistant prosecutors based on how we wrote. And this is clearly somebody else. I don't know who did this, but whoever did this, they get points for just not having looked like hammered dog shit. Because that's a real problem. That was my problem with the first one. If it's hammered dog shit, it makes it even harder for people to figure out. It's hard for people to figure out what's going on at that point. And that includes people like me. If it's orderly and clean, it makes it easier for me to look at. I'm not wasting time trying to figure it out. Now, before we get far, I did find it. Somebody helped me. This is kind of Nick's. I think Nick does the best breakdown of the Frank's motion here. And I think it's very important to look at. So we'll let Nick take away his Frank's motion here. And this is Nick explaining to himself the Frank's motion.
Poe 287, show the difference, fuck face. What is the difference between the videos? Well, one says backwards internet on it. There's the difference. That's the only difference that matters, because it's different. Objection! So Frank's challenge is just a challenge to any of those statements. It says they're a lie, and says that lie is material. Now, if they make some misrepresentation that has nothing to do with issuing the search warrant, then oh well. Hold it! That's not the question. The question is, why didn't the cop just not lie? So if you're stuck in the analysis of arguing over the quality of evidence, you're way in the wrong part of the trial. Objection! The idea is that alone, like they lied once, is not enough to overturn a warrant. They have to lie in material ways that are to the issuance of the warrant. And that's what Frank's challenge is for. Hold it! Well, one says backwards internet on it. There's the difference. Objection! But did it, if they change that, if they get rid of that line, does the search warrant still issue? If so, objection! You're not in the right spot. And I'm sorry that practicing lawyers have misled you into the wrong analysis by not being competent at what they talk about. But they have. They have misled you. They have let you down. They have done so to extract money from you.
Now, yes. And before you guys go any further, this is by Third World YouTuber. Just wanted to give him credit for what he did. It's very well done. That was a very brilliant synopsis of everything that occurred. And it's funny because Red Shirt Nick is correct. Blue Shirt Nick is 100% fucking wrong. And it's very funny. It's the duality of man. It's the Jungian thing. If you want to get back to Full Metal Jacket here. But yes, under Frank's, was there a lie? If so, was that lie material? Or were they just so reckless that nobody should have relied upon that? It's where we're at. So what do we do? Duality is Freemason bullshit. Yes, the man in his shadow. All right. Let's actually get to the actual motion now. Let's get to it. So, and I will say the tone of this motion very much sounds like someone from Reddit. It's got a Reddit-y tone to it. The state is reasonably restated the two issues remaining before the court with regards to defendant's pending motion. The state's conclusion, however, is incorrect. And they claim that they've made a sufficient showing to warrant a Frank's hearing, and the defendant has shown the seizure of firearms was unlawful. Now, once again, guys, the seizure of the firearms being unlawful, that's just, it ain't going to work. That's, you find guns in a house full of drugs. Like, the cops aren't like, well, here you go, Mr. Drug Dealer, take your guns back. Like, no. Now, let's get to once again, we got an argument heading. The United States Constitution, the Minnesota Constitution, guarantee the defendant's right to be free from unreasonable search and seizure, correct? This court stands as a bulwark. It's the defense against unfettered authority of a state's police powers. I like that language so far. And while the state is correctly identified that the presence of probable cause should be determined under totality of the circumstances test, the state fails to recognize that under the totality of the circumstances, Deputy Pomplin's narrative, upon which the court is inadequate, I did a little bit of a typo there, as Deputy Pomplin's material misrepresentations and omissions render the warrant constitutionally deficient. Are you really sure about that? Because we're going to get to that. And now we have A, showing insufficient to invoke Franks. And they're saying it is sufficient. Once again, widows and orphans, chat, don't do widows and orphans. You got something like this, just hit enter, and get on to the next page. That's just a formatting tip. Free formatting advice here. So reading the laws suggested by the state would lead to a patently absurd result. We'll talk about some patently absurd things coming up. Don't you worry. The state's torture construction of the prevailing law would ensure that no defendant could ever succeed in challenging an affidavit. I don't think so here, but okay. This notion by itself offends both the warrant clause and the due process clause of the United States and Minnesota constitutions. And they're saying, it is obvious. It's obvious, Your Honor. Well, and in my Redditor opinion, as a Redditor mod, it's obvious. The substance of the defendant's motion to suppress and dismiss is challenging the accuracy of material facts in a facially valid search warrant. Therefore, the district court is not confined to the four corners of the search warrant, and the court may look to extrinsic evidence. And now they cite this case, State v. Luschau, and it's not Lolcow. I know people were thinking that. And they say, despite nearly 5 decades old, and yeah, that's true. A case could be, 200 years old. Look back to Marbury v. Madison. That's an old case. Hunter's Lesney. All these cases, they're still valid. It remains good law. And no subsequent decision in the Minnesota Supreme Court or the U.S. Supreme Court has degraded its authority. The rules articulated by the Minnesota Supreme Court are simple, finite, and include, and once again, this is where, why wasn't all this in your original motion? I still think this motion's garbage, chat, but this is written so much more professionally. It's written better. It's a better product. It's still subpar, but it's far better than what we saw before. Like, this is the stuff I was expecting the first time around. The defendant in Minnesota has a right to challenge the truth and accuracy of allegations in a affidavit which is used to obtain a warrant. Such a challenge should be made at the omnibus hearing. Okay, and he did that. The trial court should determine if the defendant had produced sufficient evidence to put in issue the truth and accuracy of the allegations in the affidavit. A defendant is entitled to some form of disclosure as provided if he makes sufficient showing that such evidence is necessary to support his challenge to the issuance of the search warrant. Okay. The trial court must rule on the validity of the search warrant either on the basis of the evidence presently before it or upon that evidence and such other evidence as it deems necessary to make its ruling. Now, this is the part here where, Nick, I think you kind of stepped on your wiener here, because number 7, I mean, there's other evidence out there. If I'm the judge, there's some other evidence out there I want to look at, and I think you know what it is. So now you kind of stepped all over your wee-wee on that one. Like, you just, raked yourself right in the balls. And we're going to get to that, though. We're going to get to that issue. Okay. So clearly this court can go outside the four corners of the warrant in its analysis of the sufficiency of a challenge to a warrant under Franks. And they state, they talk about the prosecution side in the United States v. Matheson, and it's the 8th Circuit. Remember, the 8th Circuit, and this is something I'm surprised they didn't point out here. Minnesota's not in the 8th Circuit. I would have pointed that out because why would you not point out this is not this is only persuasive? Oh wait, Minnesota is in the 8th Circuit. I'm sorry, it is. They cited what was the case they cited? They cited like a 10th Circuit case, and I'm like, that doesn't work. And they cited a 7th Circuit case, and it's like, that doesn't work. So I'm sorry, I got mixed up there, chat. My bad. We all mess up sometimes. And they say Matheson applies federal common law to a federal criminal matter. You're right, it does, but it's guidance. It's an idea. It's direction. They say the stream's not showing on your normal feed. They say Minnesota has never held the only way to make a necessary showing for a Franks hearing is to produce an affidavit. You're right, it's not, but it'd be very helpful. It would be very helpful for you, Nick, to say, I'm Nick Rekieta. Here's why this is wrong. Or I'm bringing an expert. I watched, my name's Bob Boberson. I've watched these videos. I can tell you this video is wrong. I can tell you there were watermarks. I can tell you it's been altered. And here's how I can tell you. It would be very helpful for you to have that. It would be very helpful. You should. You should. Because, once again, belt and suspenders. Reinforce your position. Now, they point out neither did Matheson itself. They said in that case, the 8th Circuit held, without an offer of proof in the form of a sworn affidavit or some other reliable corroboration, which we don't have here, and we'll get to why they don't have that, is insufficient to make the difficult preliminary showing. Now, they get to the YouTube video, and we're going to get into some YouTube explanations here, chat. We're going to get into some stuff here. We're getting a little inside baseball, so get ready for it. They say, even if Matheson applied in the incident case, the required corroboration is information readily discernible to the court, namely the altered video. Once again, this word here they use, altered. This is a loaded word. And I will be honest with you. There's nothing wrong with using loaded language. You're trying to persuade. You're going to use inflammatory language. You're trying to poison that well. You're trying to insert into the court's mind altered. Therefore, it's wrong. Therefore, it's bad. Therefore, it's not reliable. Therefore, Pomplin lied or he shouldn't have relied upon it. There's nothing wrong with doing that. That's part of the game. You're introducing these thoughts into his head. You're treating the judge like a juror. You're trying to set the battlefield. You're shaping the narrative. You're shaping the battlefield. You're shaping the conditions under which you fight. So you're trying to control the language. So I know some people are like, oh, well, that's, faggoty lawyer stuff. Yeah, that's what we do. You shape it. You're trying to, the Overton window, all of that. You're trying to change things onto your benefit. And I said, ironically, it is the state that has provided the court with evidence necessary to corroborate the defendant's assertions, and that Deputy Pomplin materially misled Judge Fisher, especially as to the origin of the video Deputy Pomplin reviewed. And they say the following is submitted in response to the state's assertion that defendant's exhibits are incomplete and create a misleading picture of the evidence provided. On August 30th, the state uploaded an exhibit that purports to be the video that Deputy Pomplin watched prior to his application. And that's, remember, the prosecutor said, fine, Judge, here, we're going to upload the video for you to see. And yes, Nick Rekieta's stream, it's a video recording. It was uploaded 8/24. This is the same video the state produced at its initial disclosure and was referenced in the supplemental reports from the KCSO. Kaneohe County Sheriff's Office. And you see here, digital audio recording interview with blank, digital audio recording interview with blank. So I'm assuming that's Nick, and I'm assuming that's April, because remember, Kayla kept her mouth shut. They said a flash drive containing videos from Aaron Imholt and the video from Nicholas Rekieta showing the white powdery substance, the full 4-hour video. Now, in the details, it's saying, I, Detective Quinn Pomplin, prepared a flash drive which contains 4 videos, 3 of which are from. Let me see if we'll open this up a little more for you guys to see, read here. Oh, that's not going to work. That's too garbage to read. Sorry. 3 of which are from Aaron Imholt's online streaming and his information that was referenced in my original search warrant of the investigation. Also in that flash drive is the Nicholas Rekieta video, where it shows him getting extremely intoxicated, as well as a short time after he returned for going to the bathroom, and he has a white powdery substance on his nose. That video is referenced in the original search warrant of the investigation. That flash drive is in the Kandiyohi County evidence system. Okay. So they say Deputy Pomplin, however, has 2 problems to supplement in his affidavit in support of his application for the warrant. He has 2 problems. First is initial supplemental report. Deputy Pomplin identifies his digital evidence as including, in his initial supplemental report, a PowerPoint video clip from Nicholas Rekieta's online podcast, which shows white powdery substance on his nose, and also a screenshot from Nick Rekieta's podcast, which shows the white powdery substance on his nose. Then they say both the PowerPoint video and the screenshot were provided in the state's initial disclosure. This is a screenshot taken of the PowerPoint video. Now, this is something I know, and guys, here's the part of this issue. Here's part of this issue. All of us watching this, I know Meme Copium brought this point up that I'm about to bring up. I know Nate and Kurt brought it up, and I'm sure a lot of you guys watching this have brought it up. I think people on the farms even brought this up. And that just shows you kind of how garbage this is. Yeah. This is the bit of the issue here. This is the bit of the problem. You know, this is the lawyers peeing the show will resume shortly thing. Yes. Notice there's no picture of Nick on here because what's him the rest of the stream going like, you know, Nick's standing there going like this the whole time. Just a drunken fucking mess, or he's coked up to the gills. So yes, I understand why we're using this screen because it doesn't hurt you. Now, here's the issue. Here is the problem with all of this. And this is where I think we have it. This is where I think Nick, you know, here we go. Here's the issues. This clip embedded in the PowerPoint presentation did not come from the defendant's YouTube channel, as is evident from the screenshot taken at the elapsed point of time of the video that the state uploaded on August 30th, 2024. Yes, and he's not alleging that. The 2 videos are clearly different, with another creator putting his or her stamp on the video on which Pomplin, by extension Judge Fisher, relied. Now we're going to get to the faggotry in all of this, chat. The faggotry of all of this. This is the bullshit. This is the bullshit part. This is the bullshit part. And here's the thing. I don't mind Nick defending himself, but he's fucking making a disaster of it. And it's not good. This is really dog shit. And this is where he fucking rakes himself. Now, let's go back up to this screenshot right here. This is the one from Cog's channel, okay? Because he's got his backwards internet on it. You know, oi, me make Cog on backwards internet. You know, does he have a license to run backwards internet? I don't know. Does he have a license? But yes, Cog is there, and you can see his channel icon, and then you see this part up here, the actual title of the video. Now let's go to this again real quick, because we're going to watch this real quick, and I want to bring something up. Because we're going to do this. And look what we see here. Look what we see here, chat. We see Rekieta versus Rekieta Law of the Franks motion. Now, is that a title? No. That's the title, but that's YouTube putting it on there. Because what happens as soon as I hit play?
Difference, fuckface. What is the difference between the video?
Notice it disappears. It's like this bar at the bottom. I'm surprised that Nick and his attorney aren't screaming bloody murder about this down here, saying, There wasn't a play button on my video. There isn't a status bar. That's all alterations. No, it's from YouTube as a media player and the way it works. This is absolute bullshit. This is absolute bullshit. And then to go even further into things, this is channel customization for YouTube, okay? This is my channel's customization, okay? You could change the banner. I could change my profile. I could change my name. I could change the handle. And then I have the description you guys see on the things, okay? My channel URL, the custom URL. If I have links I want to show, I can do that. I have contact info. And then the video watermark. See this right here? If you guys are looking, you should see this little fucker down in the corner of my screen right now. Do you guys see it down there? You guys should see it way down here on the bottom right. You watermark. But look what I can do. I can have it on for the entire video. I could customize the start time. I could put it at the end. I could change it. Or you know what I could do? I can go, we're not having one. We're not having one. Now, why is that important? Because YouTube adds that. YouTube adds that. And what I would tell you is when you download videos, when you download a video, none of that stuff comes with you. You notice that little bar at the top, up here on the top, that doesn't come with you. The little watermark down below, that doesn't come with you. Whether you download them on YouTube or you use something like this, 4K downloader, which if you guys really want to download stuff, this is the way to go. 4K downloader is really, really fucking good. 4K downloader is like the way to go with this stuff. It's a bomb. It's a bomb downloader. Yes, it's only there if you screen record. Yes, it's just an overlay. It's just an overlay. It's just an overlay. So it's been altered. No. Because you notice right away, look what do we see in the next clip. It's been unaltered, chat. It's an unaltering. It's Schrodinger's watermark. Where did it go? Where did it go? Oh no. Oh no. No, chat, it's Schrodinger's watermark. It's gone. We can't find it. Schrodinger's watermark, it disappeared. Schrodinger's watermark is gone. Nick, where did it go? And then look up here, it's gone. Cog's some sort of cyber hacker. He's the biggest hacker on the sector. He manipulated all this. He snuck in Detective Pomplin's files and deleted it. Or you know what Detective Pomplin did? Detective Pomplin went to the NSA and they deleted all this shit. Huh. I mean, like, remember, there are watermarks, but there weren't. YouTube put those on and they were downloaded. Yeah, and Miku says, I pulled up the video on Nick's Odyssey. It's still live. Yes. They promised Cog indoor plumbing if he set Nick up. Oi! We finally have a working loo here. I can't do British. But Cog wanted a working loo. So. Oh, it's there, chat, but it's not there. Now, we get to this. This is the most bullshit argument. But they also point out this is also provided in the state's initial disclosure, but it's not the defendant's original video either. The state has provided the original video or even asserted possesses it. No, you have it and you've hid it. Now, this is Nick's argument is, and I saw this argument on the farms, and it's the most accurate argument. If you go to a theater to watch a movie, Nick will say, did you watch the movie? And you'll say, yeah, I watched The Lion King. Nick will go, haha, no, you didn't. Because the original Lion King is stuck in the Disney vault. Actually, you didn't know what you've seen. You haven't seen the real thing. As his Baldo jangles freely. That's the logic he's employing right now. That's where we're at with this. Yes, it's like a cop at Denny's. Yes. Nick doesn't know what's been downloaded, like a cop at Denny's. And once again, going back to what Detective Pomplin did in his case, like in his affidavit, you have to have the most obtuse, like moronic reading of the English language to come up with what he says. And like I said, I'm not trying to help him, but we have to have some basic understandings of English. And what would a normal, reasonable person understand these things to be? Like, that's the issue here. You know, like the affidavit does not show what Nick is claiming it shows. And hold on here. Where is it? Hold on. Yeah, so here we go with the well, this is we're opening with Chrome because it's so much easier. This is the application for the search warrant, chat. Right here. Here's the application for the search warrant. As we go through it, once again, we get to the actual affidavit, okay? So here's the case background. Now, this is where we talk about how to Detective Pomplin figure things out. So here, I hate this thing sometimes. All right. So while reviewing Aaron's social media video blogs, Aaron recently indicated that he and April are getting a divorce. Okay. And they keep going. And as we get to here, we get to the 22nd. I'm sorry, we got to the wrong spot here. Aaron did a video where he talked about Nick and insinuated controlled substance use and referenced a video that Nick had put out the night before on 5/21. Okay, so on 5/22, your affiant was able to review the video that was taken off of Nicholas's YouTube and Rumble social media sites. Yes, he watched a video that was taken off of Nick's YouTube and Rumble. He watched a video that was taken off YouTube and Rumble. Guess what? He watched Cog's video. He watched Cog's re-upload. He watched it. That's where he got this from. Like, we're not... Like, this is not hard. He lied. He did. No, Nick. Literally, read it. Read it. It makes sense. This isn't a lie. Literally, you can read it and figure it out. I mean, this is... It doesn't work. Like I said, and I'm trying to be charitable here. He looked at a video that was taken off of Nick's site. He doesn't talk about the original. But here's the things he can tell you. The video is from 5/21/24, and it is. That video Cog has is from Nick on the night of the 21st. And it's of Nick in his basement studio talking about the Court of Appeals ruling he lost. Yeah. So, once again, oh, he lied and it wasn't the real one and there's a watermark. It doesn't work. It doesn't work, Nick. Literally, you can read this, and what would a reasonable person understand this to be? That's why this is going to fail. It's not going to work, guys. And we'll just keep pointing out a couple other things here. And he wrote this on the 23rd. Pomplin wrote this on the 23rd and probably 22nd as he's working on the warrant. The entire video blog is 4 hours and 4 minutes long. At approximately 2 hours and 46 minutes into the video, he leaves. And then when he returns at 2 hours, 50 minutes, and 40 seconds, he appears. to be making an excited look and has white powdery stuff on his nose. So there you go. Once again, guys, this is not... this is not like they're Nick's whining and screaming about the original. Dr. Pomplin, like, where's the word original in here? Where's the word original in this whole thing? Where's the word original? Once again, this is how lawyers do it. You shape the battlefield. Nick brought up the term original. Now we're fighting over the issue of what's original, what's not. That's not the argument here. There's no there. This issue about it being original doesn't matter. So I don't see where Detective Pomplin lied. Do the police lie? Sure. Is this a lie right here? Nope, that's not a lie. Looking at what they have makes total sense. It's not a lie. Just saying. Dan says, Control F the word original. Well, this is not OCR, so this won't work. Because this isn't, I mean, I could try it, but I don't think it'll work because I don't think it's... I mean, like, I'll just type in video. Yeah, see, it's not OCR, so it won't even bother. But here's the point. Remember, this is the issue here where Nick is talking about this problem. This whole thing about what he looked at, Dan, this is where you start. Do you see the word original in there? Nope. Do you see the word original here? Nope. You don't see the word original anywhere in there, so... And that's where I'm, like I said, guys, this isn't even hard A-logging. This is just basically like what's here. You don't see the word original in any of this. That's Nick and his attorney trying to shape a battlefield point. So let's get back to this. But they point out the two videos are very different. No, they're not. They're literally the same fucking thing. They literally came from the same thing. Isn't it funny? These came from the same thing. It's just Pomplin screenshotted YouTube and then he downloaded it. I mean, this is not hard. Once again, if you want to show there's some massive police conspiracy and lying and shit, go for it. The problem is when you can easily throw out a plausible explanation that's not being without being at all charitable to the police, just basic common sense, it fucking kneecaps your arguments. So, as the primary basis, and let's get back. Anyways, we got to get back to this, chat. We got to keep moving. We got to keep moving here, okay? We have to keep moving. As the primary basis right here, we're starting with that part. As the primary basis for Pomplin's declaration that the defendant was actively using cocaine was a white powdery substance on Nick's nose. Pomplin had a duty to inform Fisher that he watched a video with another creator's imprint overlaid, and not the defendant's actual video. Once again, chat, this is fucking retarded because he would have to say, Your Honor, this is what, that is how fucking dishonest Nick is right now. That he wants Pomplin to have to talk about this and that and the status bar. Because why aren't you arguing that's an overlay? Why aren't you arguing that's an alteration, huh? It is. It's altered. That's not how Nick's looked. I'm sure Nick is chuckling to himself. Yeah. James says, hold on here. James, you bring up, why trust the police? I'm not trusting them. I'm trusting my own eyes. What did we watch happen? And what were the police able to put together that corroborated what we saw? So, yeah, at this point, I'm not trusting the police. I'm trusting what I saw. Go back and watch that stream. Are you going to tell me that didn't happen the way it happened? Once again, You don't have to trust the cops. Trust your own eyes. Trust your own common sense. And then trust what they found. It doesn't match up with what you have. Yeah. You know, you don't have to trust them. That doesn't mean they're not right. So he needs to hire DSP's lawyer. Yeah, he does need to hire DSP's tax lawyer and bankruptcy lawyer. But like, guys, yeah, here, Nick is screaming these are alterations. Like, and the imprint overlaid it. Is that a? Well, I guess the bigger issue is that a material change? Is that little fucking thing by Cog a material change? Because remember, he also downloaded it and watched the whole thing. Remember, because he went through and found the spots where it was. So he obviously watched the 4-on-4-minute version. So he watched it without the imprints and overlays on it. Like, how does that work, Nick? How do you work that way? It doesn't work that way. It doesn't work that way, Nick. Because if he watches this one right here, chat, because Detective Pomplin watched it based on his affidavit, he went through the whole thing. He watched it here without anything on there, Nick. Ooh. Yes, he saw the initial thing Cog put up. He said, "Oh my God, this is it. This is the whole fucking stream." And then what did he do? He screenshotted that, and then he downloaded Cog's thing. So therefore, there were no alterations on it. Alterinos on it. No whatamocks. Like, you're fucking, you raked yourself with this argument. You literally raked yourself with this argument, chat. Oh, share screen. Nick literally raked himself with this argument because look, you can see there's no watermarks, nothing on there. He literally raked himself. By arguing about that, there's no heckin' alterinos. He obviously watched it. Alex Campbell's bringing up a good point. Would a jury know about watermarks and metadata? You would bring in experts at that point, so don't worry about that. Don't worry about that. Are we covering the debate live tonight? Yes, after this, we are covering the debate. Thunderstruck is saying, is that a 148th or 35th Abrams in the background? And what is the other kid on top of it? Oh, okay. So real quick, that is a 135th scale Abrams, which is funny because when I completed the other Abrams behind me, my parents are like, "Oh, here's a Christmas present." And I'm like, "Oh, it's a bigger one." On top of that is a Lego flower set that 2.0 got me that we were going to do for like a Thanksgiving centerpiece. Never get put together for last year. And then on top of that's a Focke-Wulf 190 D9 model that is like, I'm kind of scared to do it because it looks pretty technical. I'm gonna have to do a lot of work on that one. So in the meantime, that's probably going to be a wintertime project. But yes, there you go, Thunderstruck. Thank you. I saw that. Oh, you guys want to see? Okay, yeah. So the tank right there, right here, that's the tank. I did a little one. And then, yes, over here, that's the 35th scale. And then boop, boop, boop up. Are you a Warhammer fan? Yes, I am. And I played the Warhammer games and had a couple miniatures as a kid, but that was it. Yes, I have the new brush. I have an Iwata airbrush now. Yes. So we're going to keep going with this, though, chat. We got more to get through. But yes, once again, this is Nick felting himself. Because Pomplin looked at this. Because we go back to the affidavit. The entire video is 4 hours and 4 minutes long and 4 seconds. And he talks about at approximately in the video, Nick leaves to go to the bathroom. When he returns at 2 hours, 50 minutes, and 40 seconds, he appears to make an excited look and has a white substance on his nose. He's telling you. He's telling you. So obviously he's watched the full thing. Obviously, he's watched the full thing. So there isn't a material misrepresentation. You're going to be tough. Like, once again, guys, I'm not even, that doesn't even count as sweeping. That's just looking at basic evidence. He said X, they produced X. It's very clear to imply and infer that happened this way. Like, this isn't fucking rocket science, and we're not doing gymnastics to get there. And they say, especially as existence of any alleged substance is questionable. Which, once again, that is a massive cope. That is a massive cope. That the existence of a substance is questionable. Really? You're gonna tell me that it's questionable that Nick had fucking powder on his nose? Oh yeah, that was an aberration. Nick was just putting an overlay on, chat. That was him kind of like doing V-tubing. He V-tubed coke onto his nose or powdered sugar. Now, leaving Judge Fisher with the impression that he had watched the defendant's unaltered video is a material misrepresentation. No, he watched an unaltered video. He watched an unaltered video. He watched the 4-hour, 4-minute, and 4-second unaltered video that COG had downloaded and then re-uploaded. You haven't explained why that one's not valid. You haven't explained why that one's not valid. And notice he won't. Notice he won't. And guys, I'm coming to you as a defense attorney. When you know, here's the thing. When you don't have it, you don't talk about it. He doesn't have the goods on that one, and he won't talk about it because he knows he's fucked. If he had it, he would say why it's wrong. If Nick really did, he would put up side shot, boom, 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 boom of his, because he's like, I have the original. Bow, this shot's different than that shot. Bow. And he would do it all the way through. It would be like Comic Book Guy on The Simpsons doing a shot-by-shot analysis of something, frame by frame. If Nick had it, he would use it. But he doesn't. Once again, when you read legal documents, it's important to see what's being said. But it's just as critical to look at what aren't people talking about. Internet expert says, I don't like that shirt. I wasn't a trial day. I was just wearing a shirt that looked good. So, they say the state, however, is a second problem. And once again, guys, we are going to get to, in legal terms, he's getting felted. Yes, he's felting. He's felting himself. The state, however, is a second problem. The metadata on the video in the state's initial disclosure shows the state hadn't downloaded defendant's original video. Well, that doesn't really actually say anything there. And the video they did download after the warrant had been requested and issued is not the defendant's original video. Now, this is something they're trying to show, and they're saying the Nicholas Rekieta pill stream, and it was archived 5/20/24. They're saying it was downloaded on Friday, May 24th, 10:23 a.m. And that was well after everything had happened. Now, this is their argument because they're saying that the other brand in the clip may have been from the application used to make the clip. Deputy Pomplin had a duty to inform Judge Fisher that he was basing his affidavit on an altered video. Except he didn't. Except he did not. Here's the issue. And I did this just now for shits and giggles, chat. So this document is, when you download it, it's called, and here is, can I show the actual whole file name for this? Well, we're going to show it in a second because I downloaded this motion from the Minnesota court, right? I downloaded the motion, right? So it creates a file and it saves it on my computer. By Nick's logic, he actually wrote this motion and filed it on September 10th at 5:24 p.m. on Tuesday, September 10th. By Nick's logic. So Does that mean that you didn't file this till today, Nick? No. How do you know that wasn't a copy of a file? You don't know. And you don't get to go on a fishing expedition to determine otherwise. By Nick and his attorney's logic, this is the brief I downloaded that we're looking at right now. That's the brief we downloaded right now. If you look at it, you guys are going to see similar numbers and similar numbers after it. But yes, by Nick's logic, this didn't happen until September 10th at 5:24 in the afternoon, which is absolutely fucking stupid. Absolutely fucking stupid. And Dark Horse, you're right. Those details don't mean anything, and that's my point. When they come here to this part, these details, these don't mean anything. This doesn't mean shit. This doesn't mean anything, chat. This doesn't mean a goddamn thing. This is not relevant at all. It's copies. It's copies. It's full copies. That's all Nick did here. Now, you know what? Nick might be right. And here's the problem. Here's the problem. When you make arguments that are shitty and poorly planned and poorly thought out, and the prosecutor can provide a reasonable explanation for it, guess what happens? You fucking lose. That's why you have to do this right. You got to do it carefully. Now, there are ways he might be able to have made an argument that would have helped him. Sure. But these arguments, he fucks himself in the ass with these. And then once you start making arguments that are just awful and dog shit, the court, you're now fighting a battle of, it's not even the issue of lying, but you're just making retarded arguments. You're already falling behind the curve now. You're so far behind, and the state's pulling that far ahead, and you just sound like a babbling retard. And the court's gonna be like, no, fuck you guys. This is as he said, they're not sending their best. If this is your best, this is fucking awful again. If this is yeah, great. You got the formatting down. Great. You kind of got basic legal writing 101 fixed. This is garbage. This is hot fucking garbage. Yeah. This is garbage. I mean, I understand it. They ain't got nothing. Really, they ain't got nothing. I mean, that they don't have anything. That they're out of moves, really. I get it. But
you're here because you got nothing. You got nothing in court. You don't got the bookkeeper. You got nothing. Nothing. And if you were a man, you would have done it now.
I mean, I'm just saying, chat. You got nothing. I mean, and that's the point. I mean, it's just, it doesn't work. I mean, I'm really there's no limb to go out on here. They don't have it. They're making just ridiculous arguments here. These are absolutely ridiculous arguments. Talking about altered videos. And once again, going back to this point here, as Nick said in part 7, the trial court can make a determination on the validity or upon other such evidence it deems necessary to make its ruling. You know what the court could say? Hi, Nick, give me your copy of the fucking video. You're talking so much shit. Let's see what you got. And then guess what happens? I mean, here's the deal. You go into this, let's say, I don't think Nick's going to get a Frank's hearing. Let's say on the off chance he does. Part of this is going to be, well, it's altered. Even the 4 hours is altered. How? Show us the difference. You're going to show that video and it's not going to, like, if you come in there and try that and you absolutely fucking crater when there's literally no difference between them, holy shit, Attorney White, there will, like, you know, you will get gaped, like, on a scale, like, your suffering will become legendary even in hell. I can see you getting sanctioned for that, because that's what's going to happen at some point. So once again, you know, they're like, well, all necessary evidence, including who has the original copy. I'm just saying, this is not. You are setting yourself up. You're walking into an ambush. You're walking into a minefield you laid, and you don't remember where you planted him. It's like the Pink Panther. If you guys ever watched that when he's doing, I remember watching as a kid. You know, the army guy's setting up all the flags and all the mines, and like a plane flies by and blows all the flags away, and he has nowhere to go. So. So let's move on to part C. The determination letter from Children's Services is relevant and determinative. Is it really, though? We'll take a look at that, because is it really relevant and determinative? I don't know. Like I said, chat, I don't think so, Tim. There we go. So they say, once again, the state, while correctly stating the rules, reached the wrong conclusion. The screening of maltreatment reports is controlled by an entirely different set of statutes and standards of criminal offenses. The standards are much lower for screening child maltreatment reports. Okay. The state is suggesting that the failure to meet probable cause to satisfy the lower burden of proof for the clear and convincing standard the clear and convincing standard, chat, is far higher than probable cause. Clear and convincing is way higher. Like, you've got probable cause, that's like, let's call it like 30%. Then you have preponderance of the evidence, 51%. Clear and convincing, like 2/3, 60-some%. Then you have beyond a reasonable doubt, like 90%. Now, maybe they're trying to say something else, but this is poorly worded. The state is suggesting the failure to meet the probable cause to satisfy the lower burden of proof for the clear and convincing standard has no impact on probable cause to satisfy beyond a reasonable doubt. We're not satisfying beyond a reasonable doubt. It's a fucking warrant. It's a warrant. It's not beyond a reasonable doubt. Once again, this is just fucking gobbledygook. Now you're just hammering things in there, which maybe you're trying to make an argument, but you're using terms that don't fit the argument. Those beyond a reasonable doubt has a specific meaning, chat. That has a specific meaning. Clear and convincing, specific meaning, specific meaning. Probable cause, specific meaning, and specific thresholds. I mean, I don't even know why they really have this part here. They could have skipped that, because this part here makes sense here. The requisite showing necessary to initiate a child protection matter being much lower than one necessary to secure a warrant. No. No, the idea Children's Services can get involved with less than probable cause. No, that's not how that works. That's not how that works. Like, children removed from a home, you have to have a probable cause showing that they had grounds to remove the children from a home. Probable cause. Like, it doesn't work. You're telling me a child protection, like, to get kids stripped from a home, is far less than the police executing a search warrant? Ain't no fucking way. Not even in Minnesota. And I'm not even a Minnesota attorney. And I will fucking bet you dollars of donuts. And see, Nick, there you go. You can make a fat guy joke without using sandwiches anymore. Dollars of donuts. Use that one. It's free. I'll bet you dollars of donuts that the standard for getting children removed from a home and getting a children's service investigation going is not lower than probable cause. That would be unconstitutional. That would be absolutely horrible. That would be an absolutely, think about how scary that would be. Lower than probable cause? Lower than probable cause to get them to start rooting around and looking into something? That would be absolutely horrible. That would be, Nick's like, you should look at this and be scared. Like, your argument is scary. That you think that it's so low. No, that's not it. That is not it. But once again, is it really bad? Does this make any sense? I don't know. I don't know, chat. Problem is, like, once again, are people working without tools or not working with the right tools? And they say that this warrant should have foreclosed the basis for Deputy Pomplin. And even if it didn't, he had a duty to tell Judge Fisher the determination had already been made by Children's Services. The allegations have been found insufficient. I mean, they were insufficient for them to look into. The Children's Services didn't prove the conditions wrong. And see, that's where we're playing word games again. The Children's Services, CPS, would say in their reports, we received a report. We determined there was insufficient information to move forward. It's not that it's some. And now here's two big terms, chat. Insufficient and unsubstantiated. In Children's Services cases, when they do an investigation on claims, it's either substantiated or unsubstantiated. Those are the two options. Substantiated, we believe that we believe and we have evidence to believe it happened. Unsubstantiated, we couldn't find evidence to back up the claims. Okay. Insufficient information to even get to an investigation means insufficient. Notice Nick is not saying unsubstantiated in this, because that would be a lie. That would be speaking of material misrepresentations. That would be a massive misrepresentation. The claim is unsubstantiated, meaning they couldn't find any proof of this happening. No, it's they got a report and they couldn't do anything with it, so they fucking wrote it off, which is a majority of what Children's Services does. Insufficient for us to move forward. Wouldn't the fact that the cops took drugs make CPS change their mind? They got new info. Cherokee Girl. So Children's Services So here's how this thing goes. Going back to the 16th of May. We got to rewind back to May 16th. On May 16th, the pastor, the prudest of the Scandinavian incels from Nick's church, Pastor Mellon, came in and told the police, hey, I have a duty to report all this shit going wrong in the Ricada house. And he told the police face to face. The police then forwarded that information on to Children's Services on May 16th. Children's Services determined this isn't enough for us to get involved. We don't have enough to act on. So they said it's insufficient to move forward. Obviously, once they found all the drugs, the Children's Services showed up. So we're talking about two different things. We're talking about 1 week later when the raid happened. And I hope that makes sense, Cherokee Girl. And like I said, I'm not trying to make you feel like an idiot or anything here. I hope that makes sense the way we're breaking it down. Okay, that's what you thought. Okay, good. Because here's the thing: if you're thinking that, other people are probably thinking that too, and we need to be all we all need to be on the same page. So it's insufficient, but not unsubstantiated. If it was determined to be unsubstantiated, Detective Pomplin would have an obligation, I would argue, an affirmative obligation to tell the judge, oh, by the way, all that shit Pastor Melvin told us is determined not to be true. Now, here's the thing. Let's say it was determined not to be true. He could remove it from the affidavit. But here's the bigger thing, chat. Remember this. Think about this. Look at you in this, because Nate and I were actually talking about this yesterday evening. Nate and I had a little bit of talk. You need to think about this from, and when I've helped police do search warrants before when I was working as assistant prosecutor. It's the progression, it's the journey, the trajectory of this. So the police get the report from Pastor Mellon. Okay. So they go, things are going on at the Rekieta house. And then a couple days go by, and it's kind of on the back burner. They hear on the 22nd, Aaron losing his fucking mind on Steel Till Morning Show. And the detectives go, let's start looking into this. So yes, this all started, yes, the children's service stuff kind of got the ball rolling. It started getting, it primed the pump of, hey, police think something might be happening here. Okay, and then they got confirmation, hey, there's some coke stuff going on. They're like, what? And then they tried to look for Nick's stream, and they found, oh my God, Nick was doing coke last night. You see how that works? So even without the children, like all that stuff about children's services, they could argue, yes, that was found to be insufficient, or it's found to be unsubstantiated. Let's say Nick's argument, that's what he wants. Because remember, Nick and his attorney are being very careful, because if they said unsubstantiated, they'd be fucking lying, and they would be really fucking lying, like really big time lying. Right now, they're kind of shitting around the bush. They're kind of shitting around the edges. But they didn't have the balls, because they know better than to say unsubstantiated. That's a big, big point. So here, what do? They say it's insufficient. Okay, so Pomplin says that. Does that change the probable cause in the house that Nick was doing drugs and we find cocaine? You've got Aaron saying there's cocaine in the house. I've done cocaine. And then you got Nick literally the night before, dust it all up. You got probable cause. You still have it. You still have it. So. Just saying. I'm just saying, chat. This is. Because I do this, I can tell you what they're trying to do, and I can tell you what they're hiding. Because I've been in this situation before. You're hiding things. You're trying to hide stuff in your arguments and trying to sidestep around landmines as you go. But these ones are like, no, these ones are too obvious. This is just, no, this is a non-starter. This is a non-starter. This is a non-starter. So anyways, we're going to keep going, chat. We're going to keep going here. His omission was misleading, and the material, as was his failure to inform Judge Fisher that CPS had determined the incident or condition does not fit the definition of child abuse or neglect as defined in Minnesota Statutes Chapter 260E. Now, remember, going back to the warrant, guys, and we're going to have to go back to the El Warranto, Los Warrantitos, application for a search warrant, Los Aplicación. We've got some issues here. Actually, hold on. I didn't realize. Oh, I messed this up. So we got the application for a search warrant. God, I've been doing this all wrong the whole time. That's even better color. That's a better contrast. What are we talking about in the search warrant? What are we talking about in the search warrant, chattel? My chats. What are we talking about here? I believe that the following described property and things located at the Rekieta house would be, namely, controlled substances, including methamphetamine and cocaine, and items that would allow or show controlled substance use that would not qualify as legal drug paraphernalia. Notice we don't see child endangerment, child abuse. Just saying. Just saying. Do you see anything in there about child neglect? I mean, check it out, chat. Check it out. Wiggity, wiggity, what's it all about? Do you see it? Do you see it? Do you see it, chat? Do you see anything in there? Do you see anything in there? Nothing about child neglect is in this warrant. Remember, it's a building block. It's like a precursor. It gives some context and color to the situation. But it's not the end-all, be-all. So, just saying. I'm just saying, this is not... We gotta clear this up a little bit. This doesn't help him. This is a poor argument. It's not going to work. Oh. Bifront says they got busted with meth. No, they didn't get busted with meth. But to be fair, when you're looking at that on stream, the way Nick was reacting, that could have been a guy doing crank as well. And you could snort meth. And when you grind meth up, it can be powdery. It looks like white powder. And once again, I've had worries for Nick buying cocaine that he's buying coke with Fenty in it. He's getting that Fenty Wap in it, or he's getting a lot of fucking meth in it. Because those are the two things that get cut and put into coke. Coke gets cut with a lot of meth nowadays and a shitload of fentanyl. It's like I said, thank God nobody OD'd. Or thank God nobody's hooked on fucking fent, because that would be even worse. Like, I truly thank God that hasn't happened. And that's a testament to him watching out for Nick and his wife and Kayla and Aaron, that none of them fucking died or got hooked like that. You know, knock on wood. So anyway. This whole children's services thing, once again, this is a ruse. And I would argue it's a ruse. It's a red herring. Not relevant. The firearm seizure remains unlawful. Okay, well, let's look at this. The state is over-reliant on the plain view exception. I mean, not really. It's the plain view exception. It's, you know, it is what it is. It is what it is here. I mean, they were looking around and they found stuff. I mean, you know, which the defendant distinguished in his motion. The state, however, failed to address either the strong relationship between the seized and described items, standard, or the nexus between the item seized and the criminal behavior, standard, raised in defendant's motion. As such, the court should consider any counter-argument waived and grant defendant's motion. I'm not really sure about that. I'm not so sure there, you know, like, I don't think so, Tim. I don't. Yeah, I don't buy that. I'm trying to pull up. Do I have that sitting here somewhere here? MCRO. Motion to dismiss. Where do I have the one filed on 830? Okay. No, this is not the one I wanted. I think this is it. Ah, yes. Perfect. I found it. I found the state's member. God, it's hard finding all this shit on my computer. I have so many documents nowadays. Not only for being a lawyer, but from, like, doing this. So many docs. It just turns into a mess. Okay. So the state of Minnesota versus... This is the state's memorandum. So let's take a look at it. The state's memorandum here. Memorandum of law. Let's go looking through for the gun stuff. Yes, okay, so they talk about the plain view exception. Oh God, ooh, that's way too fast. Plain view. You know, they talk about the facts available to the officer would warrant a person of reasonable caution to believe the items may be useful as evidence of a crime. To justify the warrantless seizure, probable cause must be based on evidence revealed in plain view and cannot be attained after further searching of the object. Okay, Yeah, I mean, they basically they're pointing out, going back to your arguments, they're saying, well, your arguments, they basically said like, no, your argument's fucking stupid. Here's the actual law we should be focusing on. So, but once again, Nick, it's not that they're, you've won by default. They're saying like, no, that's not right. It's all plain view. And I would have to agree. It's all plain view. As much as I'd love to suppress it, and I'd make the arguments about the nexus and all that, and I've made those arguments before about what was found outside a search warrant, but you pretty much always lose those. I mean, like, let's be real. Like, you're probably going to lose that argument anyway. I don't see them winning it. And they say inclusion. It defies common sense to say the court can make a practical common sense decision. Really, can they not? It defies common sense to say the court can make a practical common sense decision, whether given all the circumstances set forth in the affidavit, including the veracity and the basis of knowledge of persons applying the hearsay information. The probable cause exists to issue a warrant, yet cannot use the same test to look at the information the defendant supplies on a motion to suppress information when the information itself come from that which was disclosed by the state in discovery. Yes, this is Nick's slick argument of saying, no, it was you who did this wrong. No, stalker child. It was you providing me the information that allowed me to suppress this motion. The defendant, pursuant to the state's suggestion, does not wish to turn this into a general probable cause dismissal. Therefore, we adjoin the state suggesting an additional briefing schedule should be set by the court. Well, once again, that's not what the state said. The state said, hold on here. They point out in Nick's motion, and this is the state's motion, the state requests an additional briefing schedule if the defendant is raising a general probable cause challenge to the warrant. So they say if Nick is going to raise it, we want more time. Notice what Nick's saying here. We therefore join the state's suggestion that additional briefing schedule should be set by the court. That's not, once again, Nick and them won't fucking say the right thing. It's all this bullshit wordsmithing. That's not what the state said. And it's one thing if you misrepresent something here or there and you're like, okay, I was wrong. But you keep misrepresenting all the way through this. You have very little credibility at that point. You have very little credibility. Nick only skis on the purest white snow, yeah. And here's the thing, like, yes, you wordsmith, guys, but you got to do it well. And I mean, this is wordsmithing that's just laughable. Like, it's not gonna work. This is a joke. I mean, this is stuff you guys are picking apart. All of you out there are picking this thing apart. You're picking apart all kinds of parts and pieces of this, and that just shows you how fucking awful it is to start with. This is the problem, chat. This is just a fucking joke. This is lolcow worthy. This is awful. You're not sending your best. You're not sending your best out there. This is the best you got. It's not good enough. Now, to be fair, am I willing to be wrong? Sure. Could Nick be granted a Frank's hearing? Yeah, it's possible. Would I bet money against it? Yeah. Because right now, what are we looking at? Could the judge say, you know what? Fuck it. You know what? You dumb faggots. Here you go. Have your Frank's hearing. But then here's the thing. When you have the Frank's hearing, Nick, you've caught the tiger by the tail. And now you're going to have to show us why it's different. Show us what's wrong. Because clearly it's clear Pomplin didn't lie unless you managed to catch him in something, which you haven't introduced the evidence for yet, so I don't know where it's at. But you're going to show your video, and then you're going to show the COG video, and there are going to be no fucking differences. And then you're fucked. So I don't really think you want the Franks hearing at this point. I mean, maybe your plan was to bully the state and kind of force them to think they have problems, and then they cut you a deal. Because I filed suppression motions before, and you get the state all panic and flustered, and they're like, "Oh my god!" And you kind of play some, wordsmith games here, and you fuck with their mind a little bit, and you take advantage. Prosecutor may be up on top of a topic, or like in a gun case, you could fuck with them a little bit because they don't know guns too well, or this or that, or you make some metadata and trip. And they're like, okay, we'll cut you a deal. Boom, done. It's what you wanted. That happens sometimes. But this ain't going to get it. This ain't working on it. This ain't working. This ain't working on it. These are the worst Jedi mind tricks. These are the worst Jedi mind tricks. I mean, this is bad. Part of when you're an attorney is you should file a motion and should pass a straight face test. And this isn't. And I'd argue this is straddling. It's one thing to lie once or twice in a motion or to get something wrong, like a material misrepresentation. You could probably get away with hiding that. But doing this over and over and over again and making all these arguments like this. Oh, chat. I would not want to do this. I would not want to hand this in. Yes, we are streaming the debate tonight, guys. It is set for 9:00. I would not want to hand this fucking thing in. I wouldn't want to get sanctioned by the court. Would the court report you and grieve you to the bar? Probably not. But I can see these guys getting sanctioned. The very least, they're going to get their fucking assholes reamed out. Like, I could see White getting his balls stomped on for this. And it's not fun. It's not fun. And I get it. White might not practice out there. So he's saying, fuck it. We're going to, full send it and we'll see what happens. Full send on that. Fucking, fire for effect. Give me a full sheath on that. But Jesus Christ, this is not a good look. This is not a good look to see how you're doing it. Oh. Am I going to pause during the debates? No, we're going to run. This is just garbage. Just absolutely garbage. Just absolutely garbage. JC Adult says they missed the chance to challenge the gun charges based on Bruin. No, because they're not there yet. That would be a later motion at a later time. I don't think they've missed that. I heard I'm the law pope. I do not fucking want to be a pope. I detest that fucking title. I will not accept it. Please don't call me the law pope. What time's the debate start? 9 p.m. So Church Builder says, who's debating, Ralph? No. It's going to be Trump and Kamala. So the Pope doesn't wear the Easter egg. He wears a mitre. So I heard Sean likes hugs the first time you meet him. No, please don't hug me. I'll do a handshake. I'll do a firm handshake. Solid handshake. So anyways, guys, that's where this is. Could Nick get his Frank's hearing? Maybe. I'm not counting on it. This is a really, like I said, it's formatted good, which lends to it. It looks better. But this is just more hammer dog shit coming out. That's been, it's hammer dog shit that's been cleaned up and wiped up so it's not smeared everywhere. It's still hammer dog shit. It's still not going to work. It shouldn't work. Nick gets it great, but I don't see it. Anime Sucks Cope and Sneed says, where is Aaron's witness unreliability, Nick? Where is it? Well, here's the thing. Aaron's not really a necessary witness at this point. He could provide, background information, sure, but Detective Pomplin, the lab tech, and then maybe a digital expert if this becomes an issue. I mean, there's really not a whole lot to this case. Really not a whole lot to this. Oh, maybe Sergeant Nestor. Sergeant Nestor, because he might explain why they got the initial call or why they started initially investigating. Sure. And then maybe who exactly found the coke in the house. Like that actual detective, I could see them doing that. But yeah, there's not a whole lot here. There's, let's say for the Candy White County Sheriff's Office when they transported that stuff. But remember, like I said before, there's no motion to dismiss, so we know it's coke. I know that people have clued on that since then, but I was just pointing out when the lab results came in and there wasn't a dismissal, that tells you the answer of what was there. There might be chain of custody issues if multiple people were involved in transporting it or handling it, and they're on the chain of custody sheets. We might have to call those people in. But yes, this is a very, very quick thing. A very, very quick thing. So that's kind of where we are, guys. So yeah. But getting back to Aaron. Sounds like Aaron, we noticed, if you notice, the affidavit has an amended affidavit. They took some shit out, and Aaron's talking today, and I kind of get the feeling some things might change. I think there might be another long night in the Baldo bunker coming up this week, which would be hilarious. But yeah, going after Aaron doesn't really do shit for you. So you run around telling the police and everybody that you're in this, polycule was all for naught. Lol. So Fernando is saying, did you show the football players pull it out of the car? Tyreek Hill? No, I'm going to cover that Thursday night, guy. I might cover that maybe tomorrow on its own, but not right now because we're doing the next stuff. And also, I'd point out Cody's statements when he was on the Jack show are kind of indicate Nick may have been sharing stuff around, which kind of really defeats the idea of any consent issues. Just saying. Let's see here. Have I seen any Haitians around town? No. Guys, the Haitians live like 3 hours away from me in Springfield. There are no Haitians. Well, I'm assuming there's people who live in Haiti in the Cleveland area. But no, the mass Haitian explosion is down in south, like western Ohio, down by Dayton. It's 3 hours away from me. Don't worry about it. So let's see here. We got a bunch of stuff to get through here. EDW Raptor says, is this what you mean by belt and suspenders? Agbound Chemist has been a member for 17 months. Thank you for that. I appreciate that. I mean, seeing those numbers like that are really cool. Hi, Sean's #1 fan, Anna. Jeez. Zero Fuck says, hi, say hi to Anna Kasparian. Hi, Anna, if you're watching this. I hope this provided you with some information. Sula is a new member. Thank you, Sula. Anime Sucks Cope and Sneed for £5 sterling. The King Sterling. Yes, says, Sean, I'm jealous of the well-groomed practicing lawyer fit. Well, I'd probably be jealous of the fat part, but yes, otherwise, thank you. You look like the perfect spokesperson for Stoney's Bar and Grill. Yes. Matt from Tinder became a YouTube member. Thank you, Matt. Thanks for the support, and I appreciate it. Trenty Boy is saying for $4.99, is Sean going to get Jimmy John's with Anna Kasparian? Congrats on reaching the mainstream, Sean. Oh, Anna's classy. I'd take her to Applebee's. Jimmy John's is a little too pedestrian. I'd take her to Applebee's. Or maybe a Chinese buffet. I bet she likes a good buffet. Who doesn't like a good buffet? Also, thank you, Trenty Boy. I think you haven't seen you around before. Thank you for being here. Peacenik is saying Anna's worthy at least of a sandwich from Tommy's in Coventry. I have never been to Tommy's, but I've heard of it. Like, geez, man, we might have to shoot our way in and shoot our way out of Coventry, so be a little risky. Nico's been a member for 10 months saying the Baldo is almost absurd. This is filing as a close second. Yes. Fully saying, so you're saying Nick wrote the first motion, his attorney wrote the second. I'm not. I'm just saying it's kind of like when you're watching, it's like Boondock Saints. You know, when they go to when there's the porn, when they're at the porn store and they shoot up the guys in the little Jack Shacks. And, you know, the detective, the FBI agent goes like, good shooting, shitty shooting. It's like good writing, shitty writing. I don't know who did it, but I know one was shittier than the other. The content was equally shit, but at least it was, you know, it wasn't a Bondo buggy that rolled up here today. It was a car with a brand new bodywork done. So no, I won't say Nick did it, but maybe he had input. Wouldn't be the first time an attorney who hired, you know, where an attorney has a lawyer for a client, you know, works with that guy. Anime Snucks, Copitz need for another £5 sterling. Once again, for the King, Sterling says, note the complete absence of argument in this reply about Aaron's supposed unreliability. Nick didn't want to elaborate on it. Very good point. And that just kind of upped and vanished like a fucking fart in the wind. It is telling. They were streaming down arguments. Tim and Tams for $5 Australian reduce says, have fun spending some money for your date with Anna tonight. Thank you. Michael Hickson for $5 says, yo, Sean, nice suit. Looking flying professional for a stream. A perfect counterpoint with today's person of interest. If I had time, I'd be sitting here in a t-shirt or a polo. I just didn't have time to change. Roscoe P. Coltrane is a new member. Thank you, Roscoe. Roscoe says for $5, Sean, I need help. People don't want to buy tickets for my totally legit giveaway. How will I buy my new CB radio now? Well, you can always sell your EBT card for 50 cents on the dollar. I mean, that's the going rate for things down in that's the going rate for things in Carroll County, I'm pretty sure. Just a thought. Jefferson C. Post for $5. Thank you, Jeff. Not like I've seen you around before, so thank you for being here. Sounds like Nick is delving into commie word games. So sad. I mean, to be fair, that's what we do. We play word games. It's just these are like fucking Reddit tier, like 17-year-old word games that are just fucking garbage and laughable. But yes, these are getting really obnoxious. And then Janimal is a new member. Thank you, Janimal. Thanks for the support. Jefferson Post says, wouldn't fair and true representation be the real limit test to use anyway? Yes. You know, when it comes to it, is this a fair and accurate representation of what you saw or what you came across? Sure. Now, if I was the prosecutor, I've already made a subpoena to Nick. I'm subpoenaing the video from you. Because if Nick wants to play this fucking game, fine, you're going to give it to us. You admit you're holding on to evidence, guess what? You never admit to that because the prosecutor can ask for it. Never admit to holding on to evidence. Because fuck going to Google, it's quicker to go to Nick. And Jefferson, you're right. And that at that point with the original, you know, the prosecution will be able to say this appears to be a true and accurate representation of the original. Anonymous says for $5. And yes, also a fair and accurate representation of what you saw, like, is a normal foundation claim when you're dealing with exhibits. Like, you know, is this picture in the same or substantially similar condition when you found it? Is this gun in the same or substantially similar condition as when you found it? Yes. Or, you know, is this bag of drugs the same or substantially similar condition as when you found it? Yes. Anonymous for $5 says, Sean, no! Why did you start while I was at work? Love you, man. What did I miss? You missed everything. Anonymous says again for $5, says, come on, Sean. Nick was just baking. That's powdered sugar. He can make that argument. And Michael Martin for $5, also no relation, says, Nick's pick is from the media player. Cops a screenshot from YouTube. Disingenuous to compare them as comparable. Yeah, but it's the exact same thing. Like, it's literally the screenshot of that, and then literally Nick is showing the unedited and unblemished thing, which I think really is going to fuck his argument. Noah's saying, do you think Nick is calling the detective deputy and over as a sneaky insult? I don't think so. I think it's just not paying attention. Like, I've done that before. I've called it a detective. Like, there's one time in Emotion, it was like Detective Bob, and instead I called him Lieutenant Bob because he's lieutenant as well. And he might just be a detective. I mean, Detective Pomplin is also a deputy. He's still a deputy, technically. Like at the end of the day. Unhung Hero says, can't the state require the original via discovery? No, but they can subpoena it because it's evidence. They could file a subpoena. Or they could file a search warrant for Nick's phone and then get it off there and have him relinquish YouTube control. And Nick, whatever you do, if they file a subpoena, don't delete the videos. That's obstructing or evidence tampering. So please don't do that. That's actually free legal advice. Mike Middleton for $2.79 in Canadian dollars says, Sean's just dressed up for Anna. Thank you. No, I'm not. Kyle Cowden says for $1.99, he thinks Minnesota's dumb or he's too dumb to understand. I think it's a little bit of both. Anime sucks Copett's need for £2. Once again, £2 of the King Sterling. Says Sean predicted the state's response. He's right here too. Well, maybe. We'll see. We'll see. Like I said, trying to base this off my own experience. Surferbird says Nick won't go to prison. Simple possession with no background, no way. Oh, I agree. Not even prison, guys. I'm talking about Nick going to jail. I don't even see Nick going to like the Kandiyohi County jail. I don't see that. Absent him doing something really retarded. So, like I said, if the case proceeds normally, I don't see anything happening. Johan Naxos for $2 saying, Suspenders Sean is the best Sean. Well, thank you. Unforced Ego for $50. As he's saying he's probable cause for a CPS case is lower than probable cause for a criminal case because of different standards for a final ruling. Yeah, but that's still that's not the same. That's the final rulings or like what you would need for an adjudication for a children's services case is still going to be more than probable cause. It's just anyway, so not meaning the CPS PC means it possibly could meet the criminal investigation's probable cause. Sounds really dumb to me. Yeah, that's the problem. That was so poorly. I once again, maybe I'm the idiot. Maybe I'm the idiot. I just couldn't figure it out. So I'm just saying. So, but thank you for the super chat. Thanks for the appreciate it. Riley Leafson saying, yeah, Sean looking as sharp as a marble. Well, or the sharpest spoon in a drawer, or the sharpest knife in a drawer full of spoons. Either or, I appreciate it. Kyle Cowden says for $4.99, you really expect me to leave a practicing defense attorney over the non-practicing law pope? Come on, man. Well, I appreciate that. But remember, don't fall trap to the argument from an authority. An appeal to authority is just as dangerous as any other ignorant thing people can do. So, yes, base your support of the arguments based off of what I showed, not just because of what I am. And I don't think you have. I'm just saying that kind of is a generality. Thank you, Kyle. Anime sucks Copett's need for £2 sterling again. Saying Nick altered the warrant? Yes. Mario Carter 13 for $2 says, wait until Ron Toye DMs him, you're a cuck too, lol. Yes. Unhung Hero for $2 says, the Haitians ate the ceiling cats. Oh no. Oh no. The poor ceiling cats. Elephant says, pets for Trump 2020-24. Yes. And then Tomas for 5,000. AR. Is that Argentinian pesos? Yes, 5,000 Argentinian pesos. Thank you so very much. For a whopping $5.22. Um, yeah. Thank you, though, Tomas. I appreciate it. Oh my God! Since oh God, I love this. It's so damn funny. Too bad you aren't Brazilian, so you could go. Oh, wait. All right. I'd say Nick was blatantly dressed on. Nick was blatantly on stream dressed in his finest Colombian cosplay, and his best argument is timestamps or watermarks. What next? Will he get Barnes to draft a motion claiming the officers ending his property was a Third Amendment violation? Just take the L, find Jesus, and move on. Yeah. Yep. Yep. So thank you. Yeah, thank you for the red boy, Tomas. I appreciate it. Drew K is a new member. Thank you, Drew. I appreciate the support. Stacy, who's been a member for 9 months, says, save the Ducks, vote for Trump. Alex gifted 5 memberships. Thank you. And the Steel Toe Morning Show became a member. Thank you. Thanks for the support, Aaron. Yeah, and I'm hoping pointing out some of that shit with Gino and Keanu, and then I don't know if you heard about that with Camelot on the Jack show talking about like how stuff may have been going around and like Camelot's a chatty Cathy, which if you're trying to build a case on somebody is very helpful. So just saying you might want to look into that or shoot me an email. Minnie Giant is a new member as well. Thank you, Minnie, for the support. Foley says for $4.99, are Yins really paying Deshaun Watson more than anybody else to suck that bad? Well, we might not be paying him that much anymore. We're probably getting rid of that. So just saying. And yes, while we're here about the Steel Toe Morning Show, though, yes, wants to make me think about, Stoney's Bar and Grill, 158 East Broadway Street in Rockville, Minnesota. Stoney's your place to go. In the middle of happy hour chat, and it's not $2 cans on Thursday yet, but we'll be there soon enough for your Thirsty Thursday. When did you send me 2.0? 2.0 texted me. What did she say? Hold on. Yes, I'm going to do that Stoney's read for you, Aaron. Oh, I forgot while I'm here. Did I take down my Stoney's overlay? Yeah, it's gone. Sorry, I tore it down already. But yes, thank you for being here, Aaron. Hope you're having fun. Does this confirm for Pest for $2? Does this confirm Nick and Aaron shared a Baldo? I don't know if you can share a Baldo. That would be a little awkward. Like, I don't. You mean at like the same time? That would be really, really weird. That'd be very funny though. Thinking about like imagining that. Like, how would that work? Well, unless you mean like, here you go, brother. It's your turn. Okay, that maybe. Bass says for $5. Do you really believe Nick thinks these filings are good? Yes, I think he thinks he's a fucking world beater with this. I personally think he has nowhere to go, so he's just going with dumb stuff and hoping. I think he is the mayor of Copenhagen right now, but he's Hitler in the bunker. General Steiner's coming. Or he's like Bart at Camp Krusty, sitting in the corner, like, Krusty is coming. Krusty is coming. Yes, he thinks General Steiner is going to break the siege. He thinks Venk in the Ninth Army is going to save the day. The Ninth Army is not in a position to mobilize enough men or equipment to launch a counteroffensive, sir. Venk is instead carving a path through the Russians to allow refugees to escape and for his men to surrender to the United States forces. That's what's going on. Quicks for $1.99 says, Sean's free legal advice. Don't break the law. Well, yeah. That's free one. Everybody gets one. Snivels gifted 10 memberships. Thank you, Snivels. Copa Sneed for 5 months says, long live the new Law Pop, Sean. Well, are you saying like, I'm your daddy? If you're going to say it, you got to be like, daddy. Paul Myron Productions gifted 5 memberships. Thank you. Thank you very much for your support. I appreciate it. Let's see here. I underestimate the powers of the Baldo. I'm fine with that. I'm fine with underestimating the powers of the Baldo. Charlie says that was clipped. I hope it was. The content lasagna, which once again, you haven't answered my question. Are you lasagna that's content? Like it's kind of like chill? Kind of like, like in French, like somebody asks, like, how you doing? You're like, come see, come ça. Like, are you like that kind of lasagna? Or are you the content lasagna? Like you're making content. You still haven't answered that. I need to know. I'm like that guy in Dirty Harry. I got to know. And no, I can't be the law chieftain because we already have Nicholas Moran as the chieftain. So no, I couldn't do that. Yes, keep it moving, Grays. This is a green neighborhood. Although to be fair, it's not sundown yet, so you guys are safe. Nick is so cool that he thought Aaron was cool. Can you imagine? When you put it like that, I mean, yeah. Yeah. Just nasally enough, Sean. Well, thank you. I try. Sika Lothar is saying for 10 Singapore dollars. So Aaron got a mention from Anna Kasparian, Kiwi Farms, and even you too. But not the Kino Casino. Kino Casino got felted. By the way, I think I ate someone's pet. What legal trouble will I get into? Well, at least you're not going to get caned here. But yes, I don't know if she watched, I who knows? Maybe she did watch Casino, but I mean, the only reason why I got brought up is because Zero Fucks was like saying, have you subscribed to me yet? So that's the only reason why I got mentioned. If she had mentioned other people, I'm sure she knows who Worski and PPP are. That'll be just hilarious, though. It's like this next segment on Young Turks. Anna's hosting the show, like Chink's on vacation. The Baldo. And they bring in PPP and Worski to talk. That would be fucking hilarious. Oh. Obscure saying, "Oh, good logic. Shot the corns I made for him this weekend. I still have number one though because he didn't pay." Oh, French is so felted. Yeah, it's not. It's a good language. I just forgot most of it. My government, my what a mock. Yes. J-Bet saying, "Inquiring minds must know." What did I miss something? Oh, you're talking about content lasagna. Yes. I'm thinking about food. Not yet, but we're getting there. Yes, mein Lawführer. I mean, I could be the Obergruppenführer of LawTube. Can I be the law colonel like Colonel Sanders? No. Like I said, I could be the Obergruppenführer. Hellraising Angels say, "I will keep as gray as I can be." Well, hey. Gray lives matter. No, they don't. Yes. Another win for the toe. Let's see here. If Nick's lawyer wins, will he be able to take a soak in the hot tub? I mean, I don't know how that's going to work. How's Nick going to pay him at that point? But yes, maybe he is going to have a soak in the hot tub. Like I said, guys, I'm not expecting that. He could get the Franks hearing, but I don't see them pulling out the Franks hearing. I still don't see the Franks hearing happening really at this point. Scraggly says, "My sexy suspenders." Thank you. Thank you very much. Then 2.0 got him. She likes to keep me looking good. You too can ignore. Yes, Potato Bite says, "You too can ignore the greater implications." Yes. Beyond Daily says, "I second the title of President of Tomfoolery. I would eat a fucking shotgun." I'm just saying. Yes, Anime Sex Cope and Need points out, this is a rare COG W. We're all due for dubs out there, chat. We all are. So COG, you have earned this one, and 07's in the chat for COG, guys. He did God's work here. Martino Garcia saying, "Sup, how you doing?" Close the border to the Grays, yes. Did Nick put up Kayla or April as his retainer? No. Oh, no. We're not talking about that. Oh. Chris Kelly says, for £2 sterling, the King Sterling says, take this sterling unto thine coffer, good Sir Sean. Yes. Yes. You know, you can also put 40 shillings on the drum if you volunteer to come. Not like that, but you know, if you know, you know. Arcade Outpost says for $2, Ricada gives off little brother energy. Well, I mean, he is a little brother. I think he has an older sister, so that works. Or it's a half sister or something, so that checks. Snowcat Tish says, I love this weird alliance you have with Aaron. Your Stony reads 100% better than his. Stony should pay you. No comment. French is cringe. No, it's not. There are other languages that are worse. Like Yiddish would be cringe. Joe doesn't want to melt the cold fillings. Oh, no, chat, no. Oh. Obergroperführer. Close, but no. Did you hit the goal yet, Sean? Oh, I think we always hit the goal, chat. We always hit the goal when we're talking about Nick. And then Comfortably Numb for $9.99 says, thanks, Sean, you rock. Well, thank you. I appreciate that. Has Nick sent me a shower text? Not today. The Barnes Walker is the new fourth cover member. Ooh, that would be interesting. That would be very interesting. Yes, God bless the goal. God bless the goal. Hold on here. Watch out because Kale Burke, she's quite loud, yet more importantly, she's the leader of the Grays. Yes. Yes, but she's okay. She's nice. We tolerate her. Haters are bad says, when's the debate? 9 p.m. tonight. 9 p.m. tonight. Stace says Spanish is a more useful second language. I don't disagree with that, but I'm saying French is a very, very fancy, beautiful language. Does Clyde smell like pee today? I don't know because I haven't had a chance to pet him and everything, but I'm assuming he probably doesn't. He's been pretty good about not rolling in pee lately. Ozzy Mendes says, am I a Buckeyes fan? No, I fucking hate Ohio State. I'm a Michigan fan. So yes, this weekend I really thought about jumping off a bridge because it was really fucking bad. It was really a rough weekend. Tomas for 1,000 Argentinian pesos says, what's cringe about Yiddish? It's the most powerful language in the world. Also, did someone mention Steiner? I feel drawn. Well, yes, Yiddish is the most powerful language in the world. I'm not denying that. Its power is unchecked. So. So AM's asking a question. Actually, if I didn't make this clear. So is the Franks hearing now just up to the judge, or do they get to keep going back and forth forever? No, this is it. Normally you have like a motion, response, and then a reply. So it's kind of like how a witness is done. You have direct, cross-examination, redirect, and that's it. So we should be done. Now, if let's say the prosecutor believes that Nick introduced new evidence or made a new argument, they would have the right to then ask the court, we have a right to respond to that because that wasn't brought up before and that's not fair. But yes, this should be done. The judge is going to have 30 days maximum, so he could be done sooner. Now, does that mean he's going to be done tomorrow? No. But I'd say give him like 2 weeks, and he might knock out an opinion or knock out an order. Could he set for hearing? Sure. Do I think it's going to happen? No. I don't see why it would. But it could be done. It could be done. Brittany says some states you get to redirect or recross. Yes, you do. But that's not even necessarily prohibited state to state. It's just a lot of judges don't do it. And sometimes you have to have it happen, though. So, but thank you for that. It was a very, very good question. Very, 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 very good question. Let's see here. Nick Kreuzer says, yet also exiled from 109 countries. Yes. I mean, who's counting? A lot of people. Chaos says, do I ever wish I were a Sean? No. I'm happy my mom doesn't spell phonetically. I'm happy my mom spelled it the right way. So that's all. I'm totally fine with that. Totally fine with that. And I apologize. I have to take a Coke sip because my mouth is parched from all that talking and babbling like an idiot. Also, chat, if you're interested in this, just because you did it doesn't mean you're guilty. I should have brought this up earlier. Potentially criminal. You could find that at the, well, oh shit, my link might not be below. At the merch store, which give me about 30 seconds. I will put the link below for that. Hold on here. We got to fix that. Not prepared, chat. Not prepared. That's what I get for putting my crap together on the last minute. So I know some people were asking, why didn't I cover this last night? It didn't come out right away, and I already had things planned. We were watching the Michael Amiot trial, so I just didn't have time to fully read it and digest it. So that's why we didn't do it till today. So I mean, like, here's the thing, guys. And once this happens, Nick's gonna lose this. He's done. He's probably gonna have to take a plea unless he really wants to go to trial, and then it's like, the man wants to die, as Agamemnon said. What can he get as part of a plea deal? It's probably going to be plea to like the felony with some sort of like intervention or diversion program where they can go get treatment and then hopefully can get dismissed after they complete the programming. I truly hope so. Or maybe gets pled down to a misdemeanor. I mean, any of those I think are phenomenal options and very good resolutions to this. This is not something where somebody needs to be incarcerated. We have enough fucking people in prison. And I understand some of you guys may understand. I do believe in the decarceral state. We don't need as many people in prison as we have. And Nick is not somebody who should be in prison. We put people in prison because we're afraid of them, not because they're assholes. So, no, Nick should not be in prison. He shouldn't be in jail. He needs to get help. He needs drug treatment. Probably needs some substance abuse treatment. He probably needs a mental health evaluation. To be fair, we all need a mental health evaluation really at some point, especially us here. We're sitting on the internet talking about this. We probably all need a mental health evaluation. If I were Nick, what would I do? I mean, I'd have no problem fighting it, but I don't know if I'd have been going around screaming like a loon all over the internet about how it's, a conspiracy, this, that, and the other. I mean, I wouldn't have done any of this stuff. I mean, but I've been working with my attorney. What can we do about this? Is there a way out of this? Can we defeat the search warrant? No. Okay, well, can we get a good deal out of it? But there's nothing wrong with looking at it to fight it. Or trying to fight it. Also, guys, my merch should be updated there. So if you want to see it, it should be up there right now. It's a Teespring link. And sorry, Teespring charges out the ass for stuff. Do they have Sean merch at Stoney's? No, but that would be hilarious. Ben says, Aaron, what's your favorite Stoney's appetizer? And how is the calamari? I like calamari. I'm not sure I want calamari from a bar in Minnesota. I just can't imagine it being super fresh. But good calamari is just like, mwah. Do I sell hats yet? No, we're working on that. Was my mom Irish? No, but my grandfather's family was. My grandfather's family fled Ireland during the Civil War. So that's whiskey in the mug. We saw you lick the drops. Yeah. Don't forget to buy a hat for your mat and a mug for your mug. Yes. Yes, I have sent out mugs before, unlike Crowder. Yes. Do potentially criminal suspenders. Steal my idea. Go ahead and you'll make millions. Yeah, maybe I could brand some. Content Lasagna is correct. I heard a prosecutor that helped put a lot of people in prison, a lot of minorities in prison for relatively low-level offenses is running for president. Yep. Kamala the cop, career prosecutor. Yes, 100%. Oh, here we go. I got a potentially criminal pint glass. Yes, you did. Yes, you did. A lot of people did. So So Martino's saying greetings from Chile. Well, thank you. Here's some Spanish for you. Nicolas es un degenerado que usa un baldo en los cocos. We'll have to clip that. I'm sure that was brutal. I'm sorry, Spanish speakers. But yes, Mawadamak. Did Nick send any shower chats today? No. Who do you take after with gray hair? My grandfather. My grandfather went gray really quick. He flew airplanes in the Navy in the 50s, though, so I'm assuming that put a lot of gray hair on your head. Say. I nailed it? Okay, good. I'm glad I nailed it. I thought it'd be like huevos would be like we put the baldo on your huevos, but yes, Chile, home of the great Pinochet. Yes, mi general. Yes, the great generalissimo Augusto Pinochet. Rip to the real ones out there, chat. Rip to the real ones. Lack of B vitamins and genes give you gray hair prematurely. Huh. Well, the genes definitely did. I don't know about the lack of B vitamins. All right, guys. I think we're all caught up here. I think we're all caught up. I think I got all the super chats, everything else out of the way here. So that is it, guys. Now we're into the now we're in the waiting period. It's the waiting game. And we'll see what happens. You're saying huevos is your kitten's namesake? Yes, so guys, at 9 p.m. we are going to cover the debates. But yes, now it's the waiting game. We'll see what happens from here. Obviously, what's going on Aaron's case is going to be very interesting, and seeing what happens overall will be interesting too. But until then, there's not a whole lot. Oh, Pinochet's your cat's name. That's based. Oh, I forgot about that. That is based. I'm sorry, I forgot about it. So you got ice cream for debate watching? Well, that sounds like fun. Anyways, chat, thank you all for being here. I appreciate it. All of you that were here, guys. Thank you so very much. The 4 of you watching on Twitch, the over 1,600 of you still here on YouTube. Guys, please like this. Give me a like if you're down there. That helps fuck with the algorithm enough. And then if you guys are new, we cover all kinds of stuff, not just stuff related to Nick, and that stuff just related to the sector. We cover all kinds of stuff that's going on out there. Like P. Diddy just got $100 million judgment against him. Apparently he defaulted on to some criminal, like inmate out in Michigan. But we also do a Thursday night show. I wanted to tell you guys about that before we got too far. A lot of stuff to talk about already. Sean Kingston is in court for dealing with fraud charges. Trump updates. His case in New York City, the sentencing got continued until after the election. Matthew Perry, in his death, one of the doctors involved giving him ketamine has pled out. Brian Koberger's venue got moved. Tyreek Hill's arrest, and that whole traffic stop nonsense. And then also the Georgia school shooter and his dad had their first appearances in between last Thursday's show and this Thursday's show. So we'll be going through that and just, other stuff that does pop up in the meantime. And if you guys are new, like I said, every Thursday night at 9:30, we get to hang out. It's always a fun time. If there are Ricada updates, we'll throw them in there too. So I want to say again, thank you all for being here. Thank you everybody who's a membership, bought memberships. And then thank you all the super chatters. And like I said, everybody here in comments, you guys make it work. Otherwise it'd just be me talking to myself. It'd be really boring. So as always, chat, until next time, just because you did it does not mean you're guilty. Even Nick right now, he may be retarded, but he's not guilty. You might think that's a distinction without a difference, but I think that distinction still matters. So good night, chat, and take care.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy Rick hated yelled at?